SJC-12743, Commonwealth v. Wilson, Goncalves-Mendez.
Ms. Campbell, good afternoon.
Good afternoon, and may it please the court, Julianne Campbell on behalf of the Commonwealth. I'm here today asking that this court vacate the motion judge's allowance of the defendant's motion to suppress both evidence and statements. This court wisely stated that where an owner was unable to drive a vehicle away, we consider whether the owner or authorized driver offered the police a lawful and practical alternative to impoundment of the vehicle. And as a preliminary matter, I want to say that I do understand the motion judge's findings here, and that she specifically found that the defendant was not given an opportunity to voice what he would like done with the vehicle, and that he was not asked what he would like done with the vehicle. But I would turn this court's attention to page 37 of the transcript, in which the uncontroverted testimony of the officer, the arresting officer, was questioned. And you're saying that Mr. Goncalves-Mendez never asked you or anything to let the other person take the car. Not from my recollection, no, sir. Question, did you ask him if he wanted to take the car? Answer, I believe so, sir. So again, while I understand—
But the problem is that the judge, I believe, specifically said, if I don't write it, you shouldn't assume that I credit it.
She certainly did, and again, I respect that the motion judge is the finder of fact. However, this testimony was uncontroverted, and I would suggest—
Doesn't mean she has to believe it.
I acknowledge that.
So, and didn't she find that he had no opportunity to say no? Don't we have to credit that unless it's clearly erroneous?
Well, you certainly have to accept the judge's findings unless it is clearly erroneous. However, an absence of— she certainly is free to not credit that.
And in fact, she didn't credit something else as well.
That's correct.
Yeah, she didn't credit the document.
That's correct.
He also only said, I believe so, right?
I
It was,
apologize.
he also only said, I believe so.
That's correct, and I acknowledge that. But I'd like to say that I think the clear rule that this court has stated in Oliveira is supported by a long body of cases, Eddington, Ellerby, Caceres, and that's just to name a few. And nowhere in those cases, except of course in Chief Justice Gantz's concurrence in Eddington, has this court indicated that the police have a duty to inquire of an arrested driver what he would like done with arguably the most valuable possession one might have, their vehicle.
Doesn't that cut against you?
No, because
A very valuable item that you might want to get somebody's input as to what to do with it?
certainly, but what I would say to that, Your Honor, is that the body of cases have suggested that the defendant or an arrested driver is the best person to know what he would like done with his vehicle. And if he were to provide an alternative solution, I do not dispute that the officers would have had to abide by it, but he did not do so here.
But the whole thing we're trying to eliminate with inventory searches is the exercise of, discretion.
Yes.
Because we don't want judgment, we don't want these to be investigatory. So one police officer conscientiously says, hey, does your passenger want to take the car? I see he's got no record, he's sober. And then the next street over, there's a stop by the police, and they don't ask the driver, hey, do you want your passenger who's completely available to drive it? That infuses the discretion that Ellerby and the case law is so concerned about, so that the inventory doesn't become investigatory.
But I would suggest that Oliveira alleviates that discretion by saying that when an individual proposes an alternative, the police must honor it. And that's been the controlling case law, and I'd suggest that it should continue to be the
Well,
controlling
isn't
case
it
law.
more that we just haven't decided this issue? Not that that's a controlling case law?
I'm sorry, I
Isn't it more that we just haven't decided this issue?
I would acknowledge that certainly this question has been left open. However, I think that Oliveira alleviates the concern of a discretionary implementation of an inventory policy. And there was no indication here from the record that this was a pretextual inventory policy or search. And I would also point to the fact that here, this is unlike many other cases that this court has considered with respect to reasonable alternatives, because in this specific case, unlike Abdallah, there is no indication that a passenger was in fact willing to take the car. There's nothing in the record that suggests that passenger said, "I'll take it."
But the police officer, in the performance of his duties, and we certainly know why, ran the information of the passenger and found out that he was licensed to drive,
Yes.
right? So, I mean, the fact that he doesn't have any warrants is particularly important because he's not going to be under arrest, right? That's one
Certainly.
reason why they run this
Yes.
information. But then he finds out he's a licensed driver, which is curious. What difference does it make if he's a licensed driver unless he's going to have the ability to take the vehicle?
I would say that the reason they ran his information was because he was not, he did not have a seatbelt on, which is why they took his license, not in fact to determine, can we let this guy take it or not? And there is no, the
They're going to do
passenger.
that anyway. They're just going to run everybody, properly so, they're just going to run every information of everybody in the car to know that they're not releasing Charles Manson, right? That's what they're doing.
Well, I don't know that I would necessarily agree with that, Your Honor, only because the police can't ask for identification of just an occupant of a vehicle absent a basis to do so. So I don't think I can agree with that.
Is it really realistic to think that a defendant's going to know that he can ask to have his passenger drive the car? I mean, you know, if we want sort of consistency, and as Justice Lowy just pointed out, don't we want to put the obligation on, hey, do you want, you know, how do you want us to handle this? Do you want, you know, especially when they know that the guy is licensed to drive in the back?
And assuming the question that the driver isn't a law professor teaching criminal procedure.
I would have made that assumption, Your Honor, but
Even if they were, they wouldn't necessarily know the answer to this question because it hasn't been decided.
which is also my fallback argument with respect to the police acting reasonably in this case. However, to answer your question, I would suggest that we impose that obligation in a number of certain circumstances. The first that came to my mind was in the context of field sobriety tests. Certainly, a person does not have to complete field sobriety tests.
But you ask, don't they, it starts with you ask, the police officer's asking, right?
I don't know that I necessarily agree with that as much as it is, please get out of your vehicle. I'm going to have you
But
perform
that's
some field sobriety tests.
investigatory. You know what I'm having a hard time, and maybe you can help me. What I'm having trouble understanding is, why shouldn't the police ask? What's the reason not, I can't think of one reason why they shouldn't just say, hey, do you want Mr. Rodriguez to drive the car?
So I acknowledge that this is perhaps the most clean-cut and pretty case for this court to have taken direct appellate review on. I can't dispute that. However, that's often not the reality, and so I think that there are larger implications at play at the suggestion of putting this bright line rule and putting the onus on police, such as the purpose of the tow and the inventory policy is for the police to enact their community caretaking function, and that this vehicle did pose a danger to passing motorists and to others in the area, and it certainly could not be left in the left-hand travel lane. That being said, you know, the police, in executing this community caretaking function, they're not a concierge service. And I say that because this could open up quite an array of situations and how far that this can really go. If the passenger is not there, must the police wait some unknown amount of time for someone else?
Have cases that say they don't have to do that?
Correct, which is why I would suggest that in line with that body of case law, the onus should not be on the police to inquire what an individual would like done with their vehicle. And I'd also suggest that this could extend further to booking policies. And if an individual is being arrested at booking and his property is being inventoried, well, please, hold on, police officer, I'd like my mother to come here and take all of my things that you're currently in custody of, and I don't know when she'll be here. I think that there are larger implications at play in deciding this case, and it must be acknowledged that this is the cleanest cut case for this court to review that on, but it's not necessarily the reality that police are faced with in taking on arresting an individual, a vehicle left in a travel lane, and perhaps busy urban environments.
But the issue is not, does it have to be moved? The issue is, the police should not want the car. I mean,
Agreed.
there should be no investigative purpose. It's a pain in the rear to have to deal with the car.
Agreed.
So it's a pain in the rear for the police, because
Agreed.
somebody say you damaged my car or you stole something.
Agreed.
And it's a pain in the rear for the individual, the owner, because now they've got to pay according to the amicus, about $240 to get it out.
Yes.
So why is it so hard to do what Lefebvre and a number of other model rules for law enforcement simply say, is that, listen, we're going to need to take the car in for safekeeping unless you tell me of an alternative that's a reasonable alternative. And then the person can say, either, I need to wait for my wife coming in from California, and you can say, forget about it, or you can say, my buddy here will just take the car. It's not that hard, and it may avoid the police the burden of having to have the car towed, which it doesn't serve anybody.
And I acknowledge that, but again, I think that, and I don't mean to overemphasize the point that this is obviously the exemplar case for this court to hear, but I think that this court is not ordinarily concerned or involved in regulating the sort of minutia of police affecting something like the maintenance of property. And what I would suggest is look at the obligation of the police to inform an individual who's arrested of a right to a telephone call. That was something that the legislature enacted. And I would suggest that this could certainly be something that the legislature could enact by putting that onus on the police. But it's not, this specific case does not lend itself to creating a bright line rule across the board due to the number of implications that would be at play.
But the problem with your argument of intrusion is that it's a warrantless search, and the burden is on the Commonwealth to justify a warrantless search, and if it doesn't, it's a constitutional violation. So, and it's the role of a court to determine when it rises to a constitutional violation. So we're not telling you what to do. You don't need to do it. We just then may suppress it. We do what we do, and you can do what you do. So why is it not appropriate for us to say, if you fail to meet your burden of proving reasonable justification for having conducted this warrantless search, we're going to suppress it?
And I would simply say, Your Honor, that I think in terms of reasonableness of the actions of the police, Oliveira is a perfectly acceptable guiding.
Yeah, but the problem you have with Oliveira, which I happen to write, is that the facts of Oliveira involved the police told the defendants that Violet's vehicle would be inventoried and towed. The defendants became visibly agitated, and Violet stated that he wanted his girlfriend, the registered owner of the vehicle, to come and pick it up rather than to have it towed. The police did not honor Violet's request. So the facts of that particular case spoke to somebody having the opportunity to in making a request, and we said you should have honored it. This is a case in which the person did not have any opportunity. So it doesn't say that, it doesn't, we didn't reach the issue, which we will have to reach here, is what if you don't have an opportunity to make that request?
Certainly, but I think that this harkens back to Justice Kafker's question, and I think Oliveira demonstrates a reasonable person is certainly capable and willing to let the police officers know when they want an alternative disposition of their vehicle. And I would also, just as an aside, I know that this wasn't known to the police officers at the time of the tow, but the defendant himself in his recorded interview states, "No one else drives my car. I don't let anyone else take it." This defendant did not offer a reasonable alternative because he did not want one, and I would suggest
You know,
that.
you're not saying he wanted the police to do an inventory search of the car.
No, but he did not voice that he wanted the passenger to take it.
But
I
my
don't know
point
about-
is, given the, I mean, maybe he didn't know that he had that option.
Also, he
As
had a
between
choice.
having the police take it and his friend take it, he might have allowed his friend to drive the car in that instance.
But the friend would also have to be willing to take it, and
Yes, and
again,
that's why you ask.
but again, there's no evidence in this record that any of that existed, that anyone was willing to take
That's
the
because nobody
vehicle.
asked.
I
The
understand,
facts are the
but
facts.
I still maintain the position that the bright line rule that is easy to implement and to ensure the safeguards of someone's vehicle, when balanced against the police's role of the community caretaking function, is achieved by putting the onus on the driver.
Would this be enough of a bright line rule when the police have a passenger right there who is licensed to drive with no impediments to driving, that they need to inform the driver of whether or not he or she wants the passenger to take the car, and limit it to that situation?
If this court were to limit it to that situation, I would ask that it be prospective, given the state of the law at the point in time that these officers conducted this tow and inventory.
Okay, thank you.
Thank you.
Mr. Levin.
Thank you. May it please the court, Patrick Levin on behalf of Wilson Goncalves-Mendez. I'm going to start just where we left off with the state of the law at the time that this search was conducted. Commonwealth versus Oliveira holds not that it is reasonable for the police not to make any effort to figure out another way to dispose of a vehicle, but only that it was unreasonable for them to ignore a reasonable request. And the court has repeatedly reserved on the question presented in this case, starting in Caceres almost 30 years ago.
So if this is a new rule,
No, it's not.
no,
It's not a
no,
new rule. The rule is the police have to behave reasonably.
let me finish my question.
I'm
So-
sorry.
That's all right. So absolutely, the touchstone's reasonableness. If this has been left open, right, this issue
Yes.
of the least restrictive
Right.
alternative. Say you win, and we hold, as Justice Lowy suggested, that in this instance with these facts, police have to do that. Should this be prospective because the police don't have any notice of this?
No, the police have noticed that they have to behave reasonably and not impound a car when it's not reasonably necessary.
We've never given this, we've never made this obligation on the police, right?
No, I don't think you are right about that, Your Honor. The obligation is to not impound a car unless it's reasonably necessary to do so. The facts on the scene at this stop scream out, it is not reasonably necessary to impound this vehicle unless he refuses to let his friend take it away. And in terms of the reasonableness of the particular officer's conduct in this case, I also want to point out that he doesn't understand his own inventory policy. The judge finds that he believes that the policy requires him to impound the car anytime that it's in a place where it can't remain and the owner can't take it away. That is not what the policy says. It's not close to what the policy says.
I didn't get your escalate in 1, 2, 3 to mean that was the first alternative. I get that there's 4 alternatives, and I get that he didn't understand on these facts that he had alternatives 2 through 4.
Yes. Well, setting that aside for the moment, it is not reasonable not to understand your own inventory policy. The conduct in this case is unreasonable. And if you turn to the inventory policy, which is in my supplemental record appendix, page 4 of the appendix, page 2 of the policy, gives the police some guidelines, and it says that the vehicle should be towed when there's a danger to public safety, a danger to the vehicle being left unattended, a danger of theft or vandalism, or the possibility of false claims. Well, that's not the situation we have here. If the police had just let...
It had to be moved, right?
I'm sorry.
It had to be moved anyway,
Yes,
right?
that's exactly right.
Right, and that was about it.
Yeah, it can't stay where it is. It's in the middle of the road. It has to move. But the course taken by the police in this case is actually more dangerous than letting the passenger drive the car away. It is not it's not in keeping with the community caretaking function. The longer they have to wait around for a tow truck, the longer this potentially dangerous car in the middle of the road is sitting there. Whereas if they just let the passenger drive the car away, the danger is obviated and there's nothing more to worry about. The police conduct in this case is not reasonable. That's the bottom line.
Can I ask you, the hypothetical your sister just brought up about booking, that this will get us into, okay, when you book them, say, well, I want my watch given to my mom, or, whatever.
Sure.
How do we address that, or do we need to address it?
Well, I don't know. I mean, I don't have a lot of experience with how, in practice, police departments deal with releasing items that were seized at booking. I would expect that, in fact, it would be reasonable if the person's mother comes in at some point after the arrest to release the items to her, if that's what he wants. I'm not sure. I'm not sure how it really relates to this case, to be honest. I'm not sure. I'm not sure how it relates.
What about I guess this might be a little bit of a fastball down the middle question, so you'll have to excuse it, but if we're supposed to try to eliminate discretion when you're dealing with inventory searches, I imagine for the reason the chief mentioned, the police get rid of the headache if it's an inventory search. It's a pure inventory search. There's no investigation allowed. I imagine many police officers might say, gee, you want your passenger to drive it? And then some say that don't ask that question. Doesn't that create a discretion issue that we're trying to avoid?
Yes, Your Honor. And I think, in point of fact, the concerns that the chief was talking about are the reason that this particular question hasn't come to the court in the 30 years since Commonwealth versus Caceres. Most of the time, the police do behave reasonably. And if there's an obvious alternative to them having to go through the onerous inventory search policy and get the car towed away, they will gladly take that. And so there's a reason why this court in 30 years hasn't actually been presented with a situation where there's an alternative that is glaringly obvious at the scene that the police unreasonably disregard. It's because most police are reasonable most of the time. I also did want to draw the court's attention to Part 5 of the inventory policy that's in the record, which specifically is addressed to the conduct of the inventory search if it does occur, and tells the police that when an officer is securing a vehicle on the street which contains valuable property, he shall, whenever possible, ask the owner of the property how he wants it disposed of. When the owner is unavailable or is unable to express his wishes, then he gives it to his duty supervisor, and there's a whole process. The police themselves recognize it is the essence of reasonableness when you have no ulterior motive to just ask the person, what do you want us to do? And it's not a huge thing that we're asking for in this case. It's not even really an obligation on the police to do anything in particular, definitely not to do anything new. It's just an obligation that when they do seize and search someone's property without a warrant, without probable cause, without even any suspicion of a crime, that they behave reasonably. That's all we're asking for. And it's a significant imposition, as the amicus brief makes clear. I would urge the court to affirm.
And I assume that if we find in your favor as to the search, we don't need to reach the issue of the Miranda?
Yes, there's no need to address that. If the court has questions, I'll, of course, answer them. But
Okay, thank you.
thank you.